We do have a quorum. We actually have everybody here. Welcome. Has everyone had an opportunity to read the minutes, and anyone care to approve from October 20th's meeting?
I'll make the motion to approve the minutes.
I'll second.
We have a motion and a second. All those in favor?
Aye.
Aye. All right. Other business. Motion to nominate and elect a chairman for a one-year term.
I'll make the motion that you're doing an excellent job, and you ought to continue.
Okay, we have one motion to nominate me. Do we have any other motions? And that me is Catherine Pierce for the record, sorry.
And I'll second that motion.
We have a first and a second, or a motion and a second to nominate Catherine Pierce for chairman for 1 year. All those in favor?
Aye.
Do I got to vote for me? If I have to, okay. Motion to nominate and elect vice chair for 1 year. Do we have a motion for a vice chairman? I'll return the favor and let Mr. Dana Blair know that he's doing a good job.
Oh, thank
Make
you.
the motion to nominate him for another year.
And I'll second it.
We have a motion and a second. All those in favor?
Aye.
Aye. All right, old business. Do we want to do old business first, or do we want to take care of the new offer?
It's entirely up to you.
Entirely up to me. Okay. I guess the best way to decide that, how long do you want to be here?
I'm here for you all.
Okay. We'll go ahead and get rid of the old business then. There's a discussion for old business on the beer ordinance. And from my understanding, that was brought on by Mr. Jolly. So if you'll...
That was me. Yeah, in our September 15th meeting, I had a question that arose, which I went back and reviewed. And it is section, I didn't even write down the section number, section 8-310-6. States that neither the applicant nor any person employed by him in the distribution, sale, or manufacture of beer shall have been convicted of any violation of the laws of the state of Tennessee against the sale, manufacture, possession, or transportation of beer, of intoxicating liquors, or any misdemeanor or felony within the past 10 years. When the Quicksack came before us, they indicated that their employee who was convicted of selling to minors was still employed. So my question is that an issue that if it's an issue, do we need to address it with the Quicksack, or do we need to address it with our beer ordinance? Because by my reading of the beer ordinance, that person should no longer be employed. I think it's, and I think our bigger concern is that, I mean, that could be viewed as selective enforcement if we allow that to continue without addressing it, which is the main reason I brought that up. This is a person employed in the sale of beer. I think that's exactly what it says in 8-310-6.
I'm going to add to his comments. At the next meeting in October, we had alluded to your concerns with the gentleman that was before us at that time, who had also been a part of the sting and was also retaining their employee.
Right.
And we had informed him that we would be going back and looking at our ordinance, and that he also should go back and look as well. I kind of feel like in September, in September especially, that we overlooked that part and should have actually brought it up. I'm not sure how anybody else feels, or even how our attorney is going to advise us. But I'm kind of with Mr. Jolly on, should we not go back and address at least these two establishments that we know are knowingly employing convicted of beer sale employees?
Well, in terms of Mr. Jolly, I'll address your question first.
Mm-hmm.
I think your ordinance has what you want in it, so probably not an issue of adding or detracting language from your ordinance.
Okay.
I think what you've got before you is probably an issue of enforcement, which is basically where you were going with that. Obviously, the Beer Board's jurisdiction is with regard to whether or not an establishment has a beer permit to sell beer inside the city limits or not. So while you don't have control over who necessarily works at an establishment, you do have control over whether or not that establishment has a beer permit. So I think the way that you look at it, and you probably are looking at it this way, is employers can hire whoever they want to work in their stores, but if they want to have a beer permit in the city of Laverne, they've got to comply with this ordinance. And so if you have reason to believe, or if it's brought to your attention that somebody may be in violation of this ordinance, then you would treat that just like you would treat anything else, any other violation.
Okay.
Selling to minors or anything else they're doing. You just have to have somebody bring the charge, and I use that term loosely, not criminally, but just to bring the allegation to the beer board, and then just like a quasi-judicial body, you would need to hear proof about it to see whether or not that person works there or doesn't work there. I'd also caution it's going to be important if the board starts to hear those matters to make sure when you get in an area of criminal law where if someone's been convicted, you want to make sure that it's an actual conviction, because you can have things called diversions, which are things that people plead guilty to, but at the end of 11 months and 29 days or whatever the time period is, then that conviction is expunged and the case is dismissed. So during that kind of limbo period, there is no, quote, technical conviction, close quote, that you could say, well, you're employing somebody who's been convicted. The only reason I say that is because we've heard a lot of these applicants come up during the beer meetings and say, the police conducted a sting and these people all pled guilty and are, quote, on diversion. Well, that's a buzzword for y'all to know that even though they pled guilty, if they're on diversion, that's not a conviction. Those are just my thoughts, and I'll be happy to answer any questions.
So pretty much both of them, I do believe, if I'm not mistaken, had said they were on the diversion of the 1129. So there's really no cause for this board to bring either establishment owner back in due to the fact there's not an actual conviction that is stated in accordance with our ordinance.
Well, one of the things to keep in mind is that a diversion, and I'm talking in loose general terms, a diversion is not a guarantee that it will be dismissed. Okay, so the defendant that's placed on diversion could do something during the diversionary period that would cause the diversion to be revoked and then to ultimately be convicted. So it's kind of one of those things that you may want to monitor it to see whether or not they complete their diversion satisfactorily. And if they don't complete it satisfactorily and they're still employed, then you may have an issue. But I think the chairman's right. If they're on, so long as they're on diversion, there's not much under our ordinance you could do about that.
Okay. So would it be best to remember these two and go back to them and say 8 months from, well, less
Yes,
than
but-
that, because the diversion actually started when the sting happened, correct?
Yeah.
So we'd have to go back and check
When it
dates.
went to court.
And I guess what I'm
Right.
saying is like 11 months into it, would we just need a beer board member to go and talk to a permit holder to see? Would this be something that you as the attorney would look at, Bruce as recorder would look up? What steps can we
here's-
take to find out?
Well, it's all going to be public. As long as there's a diversion pending, that fact that the diversion took place will be public, and Bruce or I or police officer or anyone can go to the courthouse and look at it. If they get their record expunged and the case dismissed, you'll go to the courthouse and you will find no record of it.
Right.
So, I think honestly, any of you could go do that. If you want to charge me with going to look up the records, I'm glad to do it. Any police officer, if you wanted to ask the chief to, there are Laverne police officers in court all the time. You could have them check on it. It's easy to find out, I guess, is my point. You've got lots of different options to
Okay.
find that stuff out.
So just basically, and I'm willing to do this, to go back and look at the dates on the records we were given of when it was imposed by a judge, and call Ted Boyd and, okay, we're coming up on the end of this. Will you mind having someone check and get back with me on whether it was actually
Dismissed and
expunged or dismissed,
Mhm.
or did they do something for it to become a conviction? And then at that time, this board would come back to Bruce and let him know we need to send out a letter to that beer permit holder, letting him know we need them to come in with further testimony. Okay. Does that answer everybody's questions, including Mr. Jolly's?
That addresses mine perfectly.
Okay. All right. Then our new business, motion to approve or reject settlement offer From the pantry, doing business as Kangaroo Express Store number 3613 versus City of Laverne, doing business as Laverne Beer Board, docket number Rutherford County Court. And to remind the board members, this is a court case that is taking place, best of my knowledge, still on the 24th, next Tuesday, depending upon our decision.
That has actually been changed, Madam Chairperson. That was set for the 24th. The court contacted me about a week ago, and the court was unable to do it on that date and proposed some other dates. The first one we've been able to get to coordinate between my schedule, the Pantry's Council's schedule, and the court is January 6th. So this has been continued till January 6th, right after the first of the year, is when this is now set. Well, actually, there's a motion to reset it for January 6th, but that will be approved, or I have full expectation for that to be approved, absent something happening between now and then with the court.
Okay. Okay, am I missing it in the packet, or do we actually have a
Very
written
back.
copy?
It's very
Thank
nice.
you, thank you, thank you. I'm used to my 10 minutes early, people. Forgive me. Okay, I've just, looking back at this and having known this new offer for a little while, my main problem with it is the way our ordinance is written up. If we give a civil penalty, it is in lieu of suspension. How can we accept as a board an offer for a suspension plus a fine and not go against our own ordinance?
Well, there are a couple ways I think you can approach that, and correct me if I step out of line at all. I think the board certainly has the option of just accepting the suspension time, should it choose to do so. Because this is a pending lawsuit, you can a settlement arguably could contain terms that aren't captured within the ordinance, and so. And this is the offer that they've made, is to serve a 30-day suspension plus pay a civil fine of $2,500. I know if someone was coming before you tonight that had violated, that's what you'd have, is either a suspension or in lieu of, should you choose to do that. But if the board wants to stay consistent with that, I think you certainly could accept just the suspension and not the fine, or vice versa, depending on what you wanted to do with that. I don't think it's problematic, but I think you could accept this in part, and actually it would be, I guess, a counteroffer, but since it would be in their favor, I'm sure they would accept it. I feel quite confident in that. So what they proposed is a 30-day suspension, inclusive of the days that they have already served, which my understanding was their license was suspended as of the evening following the board meeting on September 15th until the court on the afternoon of September 25th stayed that suspension pending resolution of the lawsuit. So arguably they have served almost right at 11 days at present. Their counsel, in addition to offering this proposed resolution, put in some financial information, I guess, for the board's consideration. I guess the idea being for the board to understand what really is being hit here. I guess making the argument that a 30-day suspension is not just a slap on the wrist. It is substantial to some extent, I think, is where they're coming with this. And then he's added some other information about I think he's already tested or represented to the board that the pantry stores were going to enroll in the responsible vendor program and be retrained and that's all laid out here. I'm happy to take any questions.
On the Responsible Vendor Act, what happens if this comes up the third time? How far are they protected?
Vice Chairman, I'm not sure.
I've looked into that issue, and part of that, Mr. Blair, you'll see I've put in my email that addressed some of these questions that I know were coming up. And my reading of the state statute that would control this is basically if you enroll in the Responsible Vendors Act and you're certified, your clerks are certified to do this, that prior violations, there's some exceptions to what I'm telling you right now, but that prior violations, you can't use that to enhance a penalty if somebody is complying with the Responsible Vendors Act. So if it's the third time, fourth time, fifth time, you know, if they're Responsible Vendors Act, then it's the same penalty. Now, there are exceptions to that, okay?
I don't expect a third time.
Yeah, no, I
or
know.
a fourth time.
Right, but I'm just telling you that
Right.
there are exceptions to that, and I'll just refer you to my email because it kind of goes into some detail regarding the statute. And for the rest of you who are interested in seeing my email, Bruce, I'm sure will be happy to forward it to you.
Please.
You can see it.
If I hadn't already got it and just hadn't seen it yet, please.
Well, and so, and I know this is somewhat tied in. Under the Responsible Vendor Act, I understand we cannot suspend, we can only fine. Can we revoke their license if, okay.
No,
No,
it caps the civil penalty at $1,000.
And can't the responsible vendor be revoked by the state if there's so many violations within a certain time frame as well?
Well, I mean, that's kind of a question that's geared more for the state.
Right.
There's a commission that governs the certification of these vendors that sell beer.
Responsible vendors.
Right, and so that really is between the commission
State.
that controls that, the state, and those folks. It wouldn't control it all.
Well, I knew we didn't have any control, but my statement was basically just for the reassurance that they can't go on and on with violations and still be responsible vendors. The state will eventually step in and revoke that privilege.
The law provides for the state to step in and do that if it chooses to do that.
Right. Does anyone have any other questions about the offer?
Is it possible for us to break up the suspension dates? In other words, could we have them to serve 1 week during Thanksgiving holiday and 2 weeks during Christmas and New Year's Day? Is that a possibility?
No,
I wouldn't think so.
I don't think they'd accept it, to be quite honest.
I don't know why the board couldn't make that counteroffer should you choose to, and that would be subject to their,
Right.
they would have to consider that. I think a fair reading of the offers made was a continuous additional 19 or 20 days, depending on how long they've served so far.
You can counteroffer anything you want to, so long as it doesn't exceed the original
Right.
penalty that you imposed.
Okay.
Whether or not they accept it is a different proposition.
And for the benefit of all that are here, we discussed this briefly, and because we're at an open meeting, I'm going to steer clear of giving legal advice, but the court, when it takes this up, could accept what the board did, could do just about anything, up to what the board did. Could accept the 90 days, could give something in between, could reduce it
Just simply a fine.
to simply a fine.
I'm going to throw my thoughts out there. Y'all do with them what you choose.
Discuss.
Having dealt with the other side's attorney a few times in this boardroom, I don't like opening myself up to accepting the offer as it stands. I'd prefer to accept the 30-day suspension if we accept anything and take the 19 days that they have yet to serve. yeah, I'm sure everybody's mind is going, yeah, that's a little blown out of proportion in that second paragraph. But at the same time, it's probably not that blown out of proportion if you think of how much the beer sales pay for an employee. Because typically a convenience store, especially one with gas stations, the beer sales and the gas are basically paying their employees and their rent to be there, or their utilities to be there. So with that in mind, I'm leaning a little towards the 30 days. I'm a little anxious over it at the same time because I feel that the other case will come bounding back to us for the same thing. And that's the fence I'm sitting on, so whether I'm willing to accept that for both or not. Now, somebody else throw some ideas. Convince me one way or the other.
My biggest concern is like you said, obviously we gave out a similar punishment to more than one group. I mean, what kind of, every time that we suspend a license, the city's going to get sued because they know we're going to come back and lower it. I mean, I guess my feeling is the decisions that we as a board make carry no weight if we're just, go, well, sue us, hire a lawyer, and then, then we'll cave, I guess, is kind of my feeling on it. If 3 months was too long, then it's too long for everyone. If 1 month wasn't long enough, then it wasn't long enough for everyone, is my feeling. I mean, they all committed the same crime.
Personally, I think the question before us at this point, with them both pending in court cases, is who do we want setting the precedent? Do we want a judge to set the precedent, or do we as a board want to set this precedent? And if we set the precedent of your second offense, you're getting 30 days suspension, and then later on, if we get a third offense, which we don't look forward to, change that precedent and set it then for it being a third offense. But we're in that teeter-totter right now of either we set the precedent at a time,
Or a judge.
or we leave it to the judge, who may or may not get the full story of the first incident. Granted, he'll be informed it's a second offense, but didn't have benefit of what happened in this boardroom the first time as we did.
Yeah. And I understand that, and I guess this goes back to, and we've had the discussion, should there be penalty guidelines, should there not be? I personally don't think there should be, because every case is different. But I just think if the judge could set this, could change whatever our decision is, but they, just their judgment cannot affect what we decide to do in the future. But in the future, if we constantly, if we give, a month for this, 2 months for that, 3 months for this, if we show no consistency, then that's going to be a permanent problem. I guess my thought is, and I see what you're saying, we started, we did the 3 month suspension. Well, maybe now, we go back and do a month, and that's okay if that's what we want to do. I'm just thinking out loud here. That's I guess that's the way it's going to be. If we agree to this offer, then we'll just have to say, okay, well then, a second offense is a month suspension, and that's it. Otherwise, the city will get sued again.
True, and if we send it on to a judge who decides to make it just a monetary fine, and we later have another second offense that we try to do a 30-day suspension to, they now have a court case previously to go back and go,
Yeah.
Now whether they find that or not, we're leaving that in the air too, but there's that possibility.
No, that's my feeling. We can only control what happens at this table.
Exactly.
Judge may do what they deem fit, and that's certainly how the judicial process works. So,
how would it work with our ordinance if we did something like, they've indicated in the letter they've already started the process and incurred substantial fees to get themselves enrolled in the responsible vendor program. What if we did something on the order of reduce the time to 45 days, total suspension to 45 days and give them a time limit on when that responsible vendor process has to be complete. If they complete the process in the amount of time, then that takes care of it, so to speak. If they have not completed the process within that period of time, and of course be reasonable given the length of time it takes to go through that process, but if they have not completed it, then at that point they serve the other 45 days so that we get our 90 days.
Does this board even have the authority to require a beer permit holder to undergo responsible vendor?
Well, now that, I'm taking that just from the standpoint, that's part of,
The
more or less
negotiation.
Yeah.
part
Yeah.
of their
It's
offer.
a negotiation.
No, but,
Yeah.
no, you don't, but you, as Ms. Miller was just noting though, you could go back and say,
Right.
well, you know, we'll agree to 45 days, but we want to make sure, and I mean, I don't know, it may not be possible, we'd have to talk to, Derek would have to talk to Christopher about it, but, you know, just say, you know, we want to see that you've completed the responsible vendor program by 6 months or something. I mean, that's something that you could do. Now, I mean, that may make things more complicated in terms of them accepting it because they may not want to bind themselves to something they don't necessarily have control over. But there's no reason you couldn't offer that if you wanted to.
I like the idea. I just also know that we've been told 2 years running they were working on this program.
Okay.
And if we put a time limit of 6 months on it and we've been told 2 years running they're working on it, what time limit's going to come back to us in a counteroffer? Knowing that they've already supposedly been working on this for 2
Well,
years.
and I think you want to add this is our, last final offer,
Do we-
30 days, comply with the Responsible Vendor Act within 6 months, and we want your blessing on this within 10 days.
The one that just to caution the board, and Derek, you may have a different thought on this, but you may be making an offer that would be impossible for them to comply with if you put a time frame in terms of them getting in the responsible vendor program because you don't know
All the
necessarily-
responsibilities
Right, I mean, it
of
could
that.
take, it could
Okay.
take,
A year.
I have no idea. I'm just saying, I'd hate for y'all to say, this is what we want to do, and then have it get sidetracked because whatever you send back to them,
Okay.
they say, well, we'd love to do this, but we can't.
Right, I understand.
I would. That's my only concern. I think it's a great idea. I have no clue what the standard time frame is to get fully enrolled in it. I just don't know.
I mean, could we have them submit papers showing that they've begun the process? I mean, we could review it. Well, and I don't have a copy of the expiration. Do we know, does their permit expire, or are they on one of the permanent beer permits? Because
don't know.
obviously if their permit
I
expires.
don't have my book with me. I think they're one of the grandfathered.
Okay.
Yeah, I
Okay.
do too.
I was going to say that would be, an easy limit. 2 years. We would know, we would be able to check that when their permit came back. But I like that idea. I think that's a fantastic idea, actually. They say they're going to do this and take the steps to ensure, follow the Responsible Vendor Act and ensure that they don't come before us again. They're still willing to serve some of the penalty. But I agree, if there's, how long does it take to be fully enrolled? And I don't know the answer to that either. And it may depend on several factors that are out of their control or our control.
Well, if we did a suspension for the 45 days, and after the 45 days, they could come back and show us that, okay, this is the process that we're doing, and this is where we are in that process. And then we just suspend those 45 days, provided they follow through that same timeline. And if they don't, then we tack on the other 45 days at the end of whenever they breach the agreement. I also think that it's important, just looking at it from hey, we have to make an impact here. You know, and the impact is going to be trying to get this suspension whenever the impact is the greatest.
I totally
Not
understand what you're
February
saying.
or March,
Yeah.
you know, not that. But you know, during a high sales for that particular product.
Well, and I guess that's my next question. Let's say that we accepted this offer tonight. When do they begin serving the remainder of their 30 days?
I think that should
Effective
be
upon the
included in
agreement.
I would
yeah,
think.
we just include that in the counter offer.
Correct.
Okay. Because the next court date, I mean, well, if we settle, it wouldn't go to court, would be?
Right.
Okay. So,
Correct.
all right.
Or you give them a time limit to accept.
Now, would the 7 days apply to this for as far as acceptance? Or would it be,
This is a whole new ballgame.
okay, so once it's handed over, we
Whole
decide
different set
whether
of
there's a
rules.
day, how many days to
Right.
accept?
Right.
Okay,
Yes, ma'am. That's
Whether
right.
it's 7, 10,
right,
whatever.
okay. I really don't see them accepting the tie-on of the RVP. I see that still continuing this to court, without a doubt. Doing 30 to 45 days, they may very well be willing to accept. That includes the 11 already done.
See, I'm thinking 30 plus their 11 and go from there.
Well, so that's what I'm saying. If we go ahead and do 45 days,
Yeah.
we're actually getting our full 30.
Mhm.
Yeah, I caught that one. It's been a long day, but I caught that one.
Well, I would say, and as far as setting a precedent too, the other, if we ever have to come back on this again, we can say, we made an agreement with them because they, told us they were going to go through the responsible vendor program, which obviously, we are trusting that they're telling us the truth. So if we have another situation where we hand out another 3-month suspension and we find ourselves in the situation again, we can always look back on this one and say, well, the pantry, they were willing to go through, or at the time they told us they were willing to go through the responsible vendor program. So I would be, with that, honestly, I would be fine with the offer as it stands, or what either of you has proposed, 30 days from the time they accept it.
I would like to see the suspension from November 23rd to January 3rd, plus the time that they have already been suspended.
And how many days is that you just
That's
listed?
what I'm trying to figure out.
Okay.
Let's see, you figure 23rd is actually a Monday.
Yeah.
29th would be
30,
7.
40 days, would it be?
42 days. That would make it 42 days right out.
And so if we go with anything over 45, including their 11, they're going to deny us and go to court. I almost guarantee you.
Yeah.
Well,
And that could happen
we-
anyway, because this is probably a big selling time for them considering. So I think,
Well, if we pull back
if you go
5,
if you go your 30 days, they've served 11, give or take.
Yeah.
well, I'd like to see the 30 days carry through January the 3rd.
And I understand what everybody's throwing out. I guess the main thing I'm wanting to get across this board is we are setting a precedent. This is the first time we've had a second offense that we've had to decide upon. We originally wanted it to be the 90 days. It's come flying back at us in a heartbeat. Adding all the tie-ons with the Tennessee responsible vendors, with that in mind, that's going to be awful hard to, this board,
Force.
granted, we've had most of you for quite some time at this point, but as Dana will back me up on, we've not always had members that have stayed on this long. So if some of us start falling off and new ones come on, that's going to be a hard one to continue on. Where if we set just a
Consistency.
time limit,
Right.
we're doing more of actually setting a precedent for this board that can be followed later on, even once all 5 of us have moved on to other things. The more we tack onto it and add to it, the harder it's going to actually be to follow for future board members, and much easier for attorneys to go back and look up, well, this is what happened, and come back at future board members with, well, you know, hey, this board did back when. And we all know we've had attorneys in here doing that to us.
Well, I guess part of the reason that I threw that out there as far as the Responsible Vendor Act is for that very reason. Because we do know, they've said 2, 3 times, you know, we're doing this, we're doing this, we're doing this. They haven't done it. Couple of things, in my mind anyway, if we do put that as an add-on, and okay, say, show us in 60 days that you have begun the process. In all actuality, their letter right here states they have begun the process.
He stood at that podium and said he started the process a few times too.
So, he says he started the process, and we say, okay, we know within ourselves, we're not sure how long the process takes. So we say, okay, this is what the offer is, and you come back in 60 days and show us the proof that you are going forward with it. Within that period of time, we are going to do some research and find out exactly how long it takes to do that. What is involved in getting that done? So then when they come back in the 60 days and they say, here's where we are with it, we are going to be better equipped to know how long it takes. Could they have done it within that 60 days? If they could have and they didn't, then we know they're blowing smoke again.
So I take it this offer that you're wanting to make is to accept the 30 days with the
No.
add-on?
Do 45 days.
Do 45 days with the add-on of the responsible vendor under the facts that they come back in 60 days, prove they've actually started it. If they haven't within 60 days, we're reverting back to the 90?
Correct. And once we find out how long it takes to go through responsible vendor, that 60 days for them to come back and prove to us that they've started the process and they're actually going to go through with it, within that period of time, we're going to know more about what it takes to go through that process. Then we'll be better equipped to say, okay, it has to be completed in 6 months, it has to be completed in 9 months. Because we're going to know more at that point about what it's going to take to complete it. And that way, too, we're not prolonging this ad nauseum.
Okay, my next question is actually to the attorneys. If we send this back and they decide they choose to accept it, do we need to add on to this that the case is dropped? Because the case should take place in front of a judge in less than 60 days. Because did you not say January something?
January 6th.
6th, okay.
I mean, the case you probably end up.
We could arguably continue it
Right.
indefinitely, leave it on the docket, but take it off the, leave the lawsuit
Leave
out
it
there.
as a case, but
But
take
take it off the docket and continue it indefinitely until they've complied with,
the offer,
right,
and the agreement, rather.
Right.
Because they would have to agree to it for it to become
right.
something that's being done.
Now, just saying, and this may be something that we just have to work out with them, just saying that they've started the process, I don't know, that's a little vague. I'm not sure what that means, and I'm not trying to be wordy,
Understood.
but you know, we're building in some, what's being discussed, we're building in some benchmarks if in 30 days or 60 days, whatever they have started the process, and then we sounds like there's talk about us trying to determine exactly how long it will take to get through the process, and then adding that as a additional condition onto the settlement offer. I have to think through that one a little bit.
It's complicated. I think that's the biggest problem with it.
And I see them throwing it back at us
Yeah.
so fast.
And let me just say this, and I'm not saying one. I just want to make sure that the board knows this too. This responsible vendor program only applies, as I understand it, to off-site permittees. So any other establishments that come in before you, and compliance with the responsible vendor program is not required by the ordinance, and so future folks that come in front of you, this wouldn't be part of the discussion, at least at the initial stage. But we are in the middle of a settlement negotiation. We can do whatever we want to at this point. So I say that just for the board to make sure that it knows that. And then if you're thinking about any sort of consistency in punishment down the road, the RVP won't even be on the table for on-site bars or whatever that come in before the board.
Yeah, well, I mean, if we can't consider it in our beer permit, I guess it wouldn't be considered for anything unless we're in the middle of a lawsuit negotiation again. That's kind of what I was thinking earlier. It's, okay. I think we're okay accepting the offer because in the offer they are beginning and going through the process of becoming a responsible vendor. So, you know, any precedent we can always go back and say, you know, whether they did or didn't. Well, we accepted this offer because they, you know, gave us proof. As much proof as this is.
Okay, but the offer, as I understand it, that we're saying is 45 days. We're actually making a new counteroffer. We're not accepting the 30 days plus the fine in addition to start the process to be a responsible vendor. We're actually saying we would accept 45 days with proof within 60 days of how far they have gotten with responsible vendor, which we don't even have the information on how far you can get in 60 days at this point. To put that in for the attorney to take it back as a settlement. So we can't say to him, you go back and say, we expect this many pieces of paper or this many employees trained or this many stores on board, because we don't know what that process is. So we're leaving it extremely too vague for the attorney to get an agreement.
Yeah, if we haven't made a motion to do anything, I mean, I guess our only motion is to accept or reject the offer, correct?
Well, we can make a motion to send back a counter offer.
Okay.
Well, I mean,
Or do we first
you'd
make
be
the
right.
motion to
You would need
reject?
Right,
you would need
we've
to
got to
reject their
accept or
offer.
reject
Then
this.
you could-
Yeah.
I'll make the motion to reject the offer as it stands in this letter.
All right, I'll second that. All those in favor to reject the offer as it stands in the letter?
Aye.
Aye. All right. Do we have
That would give
anyone
them
who
a
cares to make
counteroffer.
a motion for a counteroffer?
All right, so that's what we need to discuss.
That's where we're going.
I'm gonna make a counteroffer that they serve 30 days in addition to what they served. I think anything longer than that, you throw on 45, we're gonna run the risk they're just gonna reject it. We're gonna be back here in a month, or it's gonna go to the judge. You know, I think serve a 30-day suspension in addition to what they've already served.
Can I add to that?
Please do.
And then we want to have an answer within 10 days whether they accept or reject.
Okay.
I think that's a reasonable amount of time for them to get
Okay.
with their business owners and find that out.
So we have a motion to make a counteroffer of an additional 30 days to be served over the 11 that have already been served, with the understanding that within 10 days, we need an acceptance.
You can
Correct.
just say the counteroffer expires.
The
10
counteroffer
days.
expires within 10 days. Okay. So, seeing how this has been a three-part thing, I guess I'll make the motion that we are doing a counteroffer of an additional 30 days.
We've already got the motion.
Okay, then you already took that one. Wonderful. Do we have a second on that?
I'll second that.
All those in favor?
Aye.
Aye. Wonderful. Do we have anything else we need to discuss? No further business. The meeting of the Beer Board is adjourned.